My name is Katie Naples Mitchell. I'm the program director of the Program in Criminal Justice Policy and Management within the Malcolm Weiner Center for Social Policy at the Kennedy School. Welcome, everyone. This is the third week of our speaker series for the fall on abolitionist politics, practices, and horizons. And we are really delighted to welcome Matthew Clair and Amanda Woog to join us today. I'd like to begin just with a kind of situating where we are in the series. So the entire series is tackling questions and inquiry into what abolitionist politics look like and what the praxis looks like for people on the ground engaging in those politics. And we are looking through the series kind of sequentially at every major phase and institution within the criminal legal system. So our last event looked at the institution of policing. This week, we are looking at criminal courts, and continuing into next week, looking at the actors and the defense campaigns within and around criminal courts. And then following that, we will have Danielle Sered here to talk about restorative justice and the abolition of prisons, and Tommy Shelby, who I think is on the call today also as a participant, who will be joining us to give some critique of abolitionist theory, and in particular around imprisonment. We're working also to finalize details on a final kind of culminating event to look at horizons and what's possible in the future, sort of a capstone conversation. And although this fall series doesn't have a specific event focused on probation and parole, we spent all of last semester looking at parole in particular. And I wanted to mention both that we have a prior event with Vinny Schiraldi, Mass Supervision, Fix It, Shrink It, or Abolish It, about his book and a recent paper that he had published, and also that he has an upcoming event with our faculty director, Sandra Susan Smith, also on the call, in person at the Harvard Bookstore on October 23rd, discussing that book. So the prior event is linked here, as is that upcoming event, if anyone happens to be in Cambridge that day and would like to attend. The other things I want to mention just at the top, this is an open meeting rather than a structured webinar. So we do encourage engagement throughout in the chat. You are welcome to share resources or offer comments or questions there. And we like this to be a participatory process so that people can ask their own questions. We'll unmute and spotlight you and join the conversation directly with our speakers when the time comes. This week, we're going to have kind of 40 minutes of presentation followed by a brief moderated Q&A, and then really try and get straight to opening it up to the floor so people can ask their own questions. Oh, sorry, I think I was muted briefly. Sorry if I cut out for a second. So in any event, we will ask you to ask your own questions directly if you put them in the chat. And I will also try to share resources that are mentioned by our speakers as they dive into the conversation. So without further ado, I'm going to welcome Matt and Amanda to I'll just give very brief introductions. You can read their full bios on the page on our website. You've probably already seen them if you're here today. They've been in the email blast we've sent out. So Matthew Clair is assistant professor of sociology and, by courtesy, law at Stanford University. His scholarship broadly examines how cultural meanings within organizations and institutions reflect, reproduce, and challenge various dimensions of social inequality, state violence, and injustice. His research has focused on inequality and violence in the criminal legal system and in legal institutions and the legal profession. And he did his undergraduate, master's, and graduate work here at Harvard, and we're really delighted to have you back, Matt. And Amanda lives with her family in Blue Hill, Maine. She is the former executive director of the Texas Fair Defense Project, where she participated in and directed campaigns to end the criminalization of poverty in Texas, including work culminating with the defeat of a new jail in Austin and the founding of Austin's first adult holistic public defender office. Prior to that work, she was a research fellow with the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania, at the law school there, and the Institute for Urban Policy Research and Analysis at the University of Texas at Austin, where she worked on publishing a database of 7,000 people who died in Texas custody, including in jails and prisons and police killings. They both have just had distinguished careers so far working on these issues, and we're really excited to invite them here today to talk about an article they jointly published in 2022 in the California Law Review about criminal courts and the abolition movement. So Matt and Amanda, welcome, and I will let you take it away from here.
Great. Well, thank you, Katie, for that wonderful introduction. And it's great to hear about the broader series as well. And thanks to everyone who showed up today. We really appreciate it. And we look forward to being in conversation with you. So I'm going to start with sort of 20 minutes. That's going to give some sort of high-level summary of the article for people who haven't had a chance to take a look at it. And then Amanda's going to give some sort of summaries and also examples of the way that lawyers in conversation with and alongside community members can sort of enact and have been enacting many of the aspects that we talk about in the paper. But to begin my sort of 20 minutes, Amanda and I just sort of wanted to have a quick sort of conversation about why we wrote this article or how we came to write this article in the first place. So Amanda and I, as you can see from this photo here of the two of us, you might be able to predict that that's in, or guess that that's in Philly where we met. So we were put together in an office at the University of Pennsylvania Law School back in 2017. And Amanda will probably tell you that my sociological background sort of helped her see things differently. But I've got to say, honestly, Amanda has always been someone who's helped me to think critically about the implications, the normative implications about my social scientific work and scholarship. But we sort of decided to write this paper together in 2020 after George Floyd was murdered. And after we had learned about Breonna Taylor and her killing and murder as well. And we were sort of struck by the public conversation around policing in prisons and the abolition movement around policing in prisons. But we also saw the various ways in our own work and in our own practice how criminal courts are a central feature of the violence of racialized systems of punitive legal control in the United States. And we wanted to really highlight existing efforts around the criminal courts, but also theorize more deeply how the criminal courts can be understood in a broader horizon toward abolition of racialized systems of punitive control. Amanda, I don't know if you have any other thoughts that you want to share about sort of how we came to write this article.
Yeah, I think I would just add that this article was in part for me an exercise in rage writing. And I say that because I graduated from law school in 2012, and in 2014, Mike Brown was killed. And when the officer who killed him was not charged with his murder, I remember watching the district attorney explain why the grand jury didn't come down with charges. And it was so odd for me watching that because I felt like he was acting as a defense attorney, the district attorney was, and like explaining the officer's actions and why they were justified. And there was nothing in my legal or law school career that helped me understand how that could be. Like I was taught legal doctrine, how to think like a lawyer. We hear that a lot. That was really a pivotal moment for me in trying to learn and unlearn more about the system that was separate from what I had been taught in law school and in case books and in seminars and lectures. And so when Matt and I met, that was definitely part of my journey. And I've always been really grateful to sociologists and other people who are working in social sciences who are doing the research to expose how courts and court systems and court actors actually are experienced on the ground. And I'm also really grateful to people who have been through the system who share their experiences as well, so that we can learn what courtrooms look like in the day-to-day and not just what they look like in Law and Order or in our case books. And so this moment that I met Matt was part of that journey, and I'm grateful to him for being part of that and part of my learning and unlearning that happened. And so this article, a lot for me, was a reflection of my experience as a lawyer and how little we were really confronting the realities of courtrooms and how they're experienced by people who are harmed by them.
Thanks for sharing that, Amanda. Amanda knows I'm always excited to be in conversation with Amanda because I think that we sort of, the way we wrote the article and also the way we talked about the article and the work is it's really a collaboration between social scientific work and analysis and scholarship, but also things that are actually happening on the ground. And I think we reflect that in our own sort of personal experiences and professional experiences. So let me just go ahead and get started with what this article is arguing and sort of the evidence behind it. Let's see, there we go. So I want to first begin by defining what we mean in this article and broadly more sort of in other people's scholarship around abolition, and what we mean specifically by abolition of punitive systems of racialized legal control and exploitation. So in the colonial era and in the first 90 years of after the United States became a country, slavery was the main system used to control and exploit Black people and communities. And many of those who were enslaved or formerly enslaved and their allies debated and envisioned how to bring about the abolition of slavery or the complete end of it as an institution. And not everyone who described themselves as an abolitionist agreed that slavery should come to an immediate end, or even that certain tactics, such as slave revolts and eventual civil war, were necessary or even appropriate ways to hasten the end of the institution. They also disagreed about whether the United States Constitution would need to be completely rewritten. Some viewed it as an inherently pro-slavery document and thus unsalvageable, whereas others saw the Constitution as a living document that could be reinterpreted in ways that aspired toward and guaranteed the freedom of all people living in the United States. So in his book, Black Reconstruction in America, W.E.B. Du Bois described some of the debates among abolitionists at the time prior to the Civil War, as well as the debates about and the failures to incorporate Black people into American society as full and equal citizens during and after Reconstruction. So an important theme that's relevant for our conversation today in Black Reconstruction is Du Bois's characterization of enslaved Black people as, at the end of the day, workers who are thoroughly economically exploited through a racialized economic system. He also provides evidence of the various ways that enslaved people fought for their own freedom, which he characterized as a general strike. For Du Bois, the abolition of slavery then was not simply the end of an oppressive and exploitive racist institution, but also the beginning and presence of robust social, political, and economic rights to those who were enslaved. And this is what he means when he talks about abolition democracy. So today's abolitionist movement in relation to the prison industrial complex is inseparable from this history. The abolitionist critique of the prison industrial complex, which Angela Y. Davis defines as the constellation of corporations, media entities, and governmental actors, and racist and capitalist ideologies that have together driven mass incarceration. The critique centers on the way that prisons and police in the US have historical ties to slavery and also continue to perpetuate racial and economic oppression. Moreover, abolition today offers not just a critique and a demand for an end to a system of oppression, but also an alternative and a demand to build up positive social institutions that seek to incorporate and protect those who have been excluded and marginalized. The work of the Black Panther Party, for instance, in the 1960s with respect to community outreach and food programs demonstrates how abolitionist organizing seeks to replace punitive institutions with those that are democratic and capacity building. This is also reflected in the more contemporary work of Critical Resistance, Mariame Kaba, and many other local organizers and groups in communities across the United States. The Movement for Black Lives 2016 platform, for instance, demanded investment in Black communities, political power and community control, economic justice, and reparations, not just tearing something down, but also building something up. So our article seeks to extend abolitionist theory and organizing to an explicit critique of the criminal courts as a central component of the prison industrial complex, and also a reimagining of alternatives for holding people accountable when they harm others. Much has been written and said about the tail ends of punitive legal social control, policing, and prisons, and we seek to contribute to abolitionist thinking by dissecting sort of that middle moment, the criminal courts, which we in this paper and in much social scientific research defines as the assemblage of legal actors, precedents, and incentives that make up the courtroom work group. And the courtroom work group are judges, prosecutors, public defenders, and other professionals that have been called in especially increasingly to do the work of punitive legal control. Social workers, therapists who are asked to come into court. Courts legitimate the activities of police and prisons, even legalizing violent and otherwise illegal activities, while mythologizing themselves as institutions that afford justice, as evident when families and friends who lose their loved ones to police violence call for prosecution through the courts. Moreover, criminal courts contribute their own unique forms of state violence, social control, and extraction, which we'll detail in a minute. So although much of the scholarly and media attention around abolition has focused on police and prisons, organizers on the ground are actually increasingly scrutinizing the courtroom work group, questioning prosecutorial practices and the use of court-imposed pretrial detention, fines, and fees, working to create the conditions for democratic, community-based power and accountability that centers those who are most marginalized, and more broadly indicting the courts as an unjust institution. So criminal courts can generally be considered, and as we frame them in the article, as unjust social institutions, both given their historical forms of injustice as well as contemporary iterations of it. And in particular, we focus in the paper on racialized forms of injustice and also economically extractive forms of inequality and injustice that target those at the bottom of the hierarchy, in particular in the United States, poor people of color. So historically, we know that after the abolition of slavery, courts, much like police and prisons, picked up the mantle of controlling and exploiting newly freed Black people. In the South, Black citizens were excluded from serving on juries, and Black defendants were tortured for self-incriminating testimony. Mass arrests and mob-dominated trials were a routine feature of Southern courts. Following emancipation, Southern planters relied on what was known as the criminal surety system as a way to continue to exploit the labor of newly freed Black people and the poor. So through the criminal surety system, planters would pay the court fines of arrested people under the condition that former arrestees would work off their debt as agricultural laborers. And this system benefited both private employers as well as courts. Tamar Burkhead writes, surplus from these payments padded public coffers as well as the pockets of court officials. And when workers' debt records were subsequently, quote unquote, lost, or there was an allegation of breach, surety contracts were extended and workers became further indebted to local planters and merchants. But it's not just what was happening in the South at that time. In the North, we also have good evidence and historical evidence that Northern courts were corrupt in their own ways, controlling and extracting resources from Black people as well as working class white immigrants. In her book, Free Justice, Sarah Mayu writes about Manhattan's criminal courts in the 1890s. She writes that, quote, low-level criminal courts operated as they had for much of the 19th century, essentially as free-for-all, where money changed hands in exchange for freedom, rights, privileges, decisions of law, and verdicts of innocence. Criminal lawyers bribed the jailhouse guards to alert them to potential clients and allow their agents free rein in the cells to interview and solicit detainees. Guards equally expected bribes from the inmates themselves in exchange for extended visiting hours, better food, and clean sheets. In the low-level police courts, lawyers screamed at each other's clients and lobbed insults at one another. Defendants crowded into the courtrooms in large groups, could little follow the proceedings. Into the 20th century, important work, especially in the middle of the 20th century, such as Ian Main's work, has shown how federal courts' efforts to standardize criminal rules and procedures in the 1940s entrenched racist procedural norms through a cloak of race neutrality that persists today. So reformers of the federal rules, many of whom were racist individuals themselves, in addition to their policy being racist or having racist effects, adopted separate rules for criminal and civil courts. In civil courts, where litigants were disproportionately white, reformers expanded the ability to participate in the legal process, discover information, and interrogate witnesses. Meanwhile, in criminal courts, where defendants were disproportionately Black and poor, reformers implemented rules that expanded state power and diminished defendants' rights, thereby reinforcing, quote, the racial ordering of the period within the criminal law arena. Now, today in the article, we talked about several ways that criminal courts perpetuate various forms of police abuse and violence, but also have their own forms of violence that they contribute to in society. First is through their immense deference to police power and abuse. So the Fourth Amendment ostensibly protects people from unreasonable searches and seizures, as well as from the use of evidence obtained through illegal search and seizure practices. Yet the Supreme Court has granted police broad authority and discretion in the interpretation of what counts as a reasonable search. In the seminal case, Terry v. Ohio, the court approved the controversial and racially discriminatory practice of stop and frisk. In the court opinion, the court determined that what counts as reasonable is according to an officer's account, not that of other people, such as those subject to the search or even just neutral bystanders. Such deference greatly expanded police power to intervene in people's lives and precluded analysis of racial biases that are often part of police officers' judgments about what looks suspicious. Since the late 60s, stop and frisk has been used to disproportionately harass and assault Black and Latino people. In 2011 alone, the NYPD made close to 700,000 stops. Black and Latino boys and men between 14 and 24 are 4.7% of the resident population, but 41.6% of those who are stopped. Police power and credibility is reinforced through trial courts. Everyday judges often have what Anna Lvovsky describes as a judicial presumption of police expertise, or a presumption that police have greater insight into crime and are therefore reliable authorities whom judges should generally defer to as witnesses. This presumption operates routinely in determinations of probable cause for an arrest or in the interpretation of vague statutes such as loitering laws, despite the well-known practice of what's known as testifying, or when police lie on the stand in sworn testimony to protect either themselves or their colleagues. Courts also accept questionable forensic evidence, and beyond judges, prosecutors who have, of course, immense power in the system and could prevent the introduction of questionable evidence from police or prosecute even abusive police practices. They are often institutionally incentivized to cover for police abuses. Meanwhile, in civil cases, police are also rarely held accountable for their actions because of qualified immunity. Courts also have their own injustice beyond what they do to legitimate improper policing. So daily courtroom acts that are considered violent by those who experience them have become normalized and unquestioned by empowered court professionals. So for instance, the routine of being brought into court from jail often involves handcuffing, shackling, and wearing jumpsuits that mark a person as a criminal rather than as a person who should be presumed innocent by law. Courts operate to control people and marginalize racial groups, all the while maintaining a veneer of racial neutrality. So in her work, Isa Kohler-Hausman documented how legal officials in New York City misdemeanor courts use various techniques to mark, test, and monitor the defendants before them, such as keeping cases open just to see how the defendant will do and whether they'll be a compliant person who returns monthly and does what the court says, or requiring various performances with drug programs simply to demonstrate that they're compliant, responsible individuals. She argues that these practices constitute a new managerial model of control, whereby officials seek to determine not whether a defendant is actually innocent or guilty, but whether the defendant is just someone that the courts can manage. In Cook County, Nicole Gonzalez-Van Cleve shows how judges, prosecutors, and defense attorneys in the Cook County, Illinois court system code racial difference as moral difference. Racialized moral labels become ingrained into court routines, such that defendants of color, who in her work are stereotyped as degenerate, lazy, and undeserving, are not afforded due process protections. And in my own work, I document how the attorney-client relationship itself at once constitutes and perpetuates various forms of racial and class-based injustices in the Boston court system. Working class defendants of color and poor defendants are rarely able to establish trusting relationships with their lawyers, making them more susceptible to coercion, shaming, and silencing from judges as well as their own defense attorneys, and also making them less likely to receive opportunities for rehabilitation and future legal assistance. Because the quality of the attorney-client relationship is rooted in prior inequalities and racist police practices, as well as the lack of resources afforded to court-appointed defense attorneys in our sort of two-tiered system of justice, the consequences of the relationship, I argue, can be understood as a covert and often unintentional form of racial and class discrimination within courtrooms, a kind of discrimination that most legal authorities do not view as problematic. And then lastly, we really sort of excavate, if you will, how the courts really function as a form of extraction, financial extraction for already marginalized communities of color. Criminal courts impose legal financial obligations on defendants that provide revenue to local and state governments and profits to businesses. LFOs include fines, fees, surcharges, and restitution that courts directly impose as punishment for an offense, such as a traffic violation, or restoration of an alleged harm or violation, such as paying sort of victim compensation. And then the third way is through requested payment for services provided by the court. So fees, for example, for court-appointed legal counsel. Legal financial obligations disproportionately burden communities of color given racialized police practices such as traffic stops and arrests, as well as court practices that uniquely punish the poor, such as late fees, additional fees for entering a payment plan, warrants issued for non-payment. And LFOs have been used by local governments to boost revenue, as we saw in Ferguson, where there was an explicit effort to actually bring people into court in order to make up for revenue shortfalls. Moreover, bail practices within courts and also the for-profit bail industry that depends on such practices are another notable example of the way that courts exploit or extract from poor and marginalized communities. People charged with crimes with their families across the country pay more than $1 billion to the for-profit bail industry every year. So over the last few decades, with respect to sort of abolitionist organizing, there have been various, and sometimes there have been various ways that we think about abolitionist principles and how we see abolitionist principles operating with respect to the movement. And so we really highlight in the paper sort of three principles that we think are fundamental to an abolitionist politics and practice. First is power shifting. This is the underlying principle that the power to define and manage social harm should be democratic. So as Jocelyn Simonson has written, the movement focus on governance and policymaking and police reform surfaces the specific role that policing plays in denying people in highly policed neighborhoods their democratic standing and collective political impact. And we argue that power shifting has both cultural and material dimensions. Cultural power shifting involves marginalized populations, exposing and re-articulating the way crime is constructed in the public imagination, for example. And direct resistance in the face of legal authority can also constitute both cultural and material shifts in relations between marginalized groups and those in power. And in this part of the article, when we're sort of highlighting these principles, we're really talking about how they've been mostly talked about in relation to police and prisons. So in the example of power shifting, cop watching is a common sort of practice that really shifts power from police toward communities who are observing and watching abusive and corrupt police practices. Cop watching can provide community narratives of police abuse and also help individuals resist abusive tactics during an encounter. And also cop watching can be used to counter police testimony in court. The second principle that we see and that we eventually articulate in relation to criminal court abolition, not just police and prisons, is what is referred to as defunding and reinvesting. So these paired acts of defunding and then reinvesting resources is the second principle that's commonly talked about and most often was talked about in relation to policing, but it's also talked about in relation to prisons. It's a way of taking resources from a carceral and punitive institution and then investing in non-carceral, non-punitive institutions that could help prevent harm and also deal with social harm and provide accountability after the fact. And then finally, the third principle is transformation. On the road toward abolition, many activists recognize the practical necessity of partial abolitions or non-reformist reforms that transform existing punitive state institutions in ways that reduce their power and harm. Transformation with respect to police and prisons has often been talked about. For example, dismantling uniquely oppressive components of the law by declining to pursue certain charges by police. It's a principle that requires careful attention to unintended consequences, such as legitimating the existing system. And the principle also forces clarification about what aspects of the system should be abolished or reformed. Criminal courts, for instance, a restructured are operating within sort of broader legal frameworks, such as state and federal constitutions, laws, electoral systems, and the like. These are a collection of supporting structures that may or may not themselves invite critique, transformation, or abolition. So in the rest of the paper, we spotlight these three principles, and we articulate how they're operating either currently in relation to organizing that's happening on the ground in relation to the courts, or ways that we think they could be operating in distinct new ways. And Amanda will talk about a lot of what she's experienced in relation to organizing on the ground in Texas and also with respect to law and lawyers. But I'll sort of briefly just highlight some examples that are in the paper. So with respect to power shifting, we describe the practices of court watching by groups of residents like Silicon Valley Debug. We describe their efforts to support their neighbors and friends in making it to court, meaning that instead of relying on pretrial conditions and services to compel people to court, we're really relying on community members to help people make it to court, give them housing and the like. We also describe how community bail funds shift power away from courts to determine who should be free while awaiting trial. Defunding and reinvesting in relation to courts could look like efforts to defund court budgets, reallocate resources from prosecutors' offices to public defenders' offices, and user pay structures such as requiring payment for lawyers. Reinvesting in structures that could be completely separate from the criminal courts as spaces to hold people accountable for harm is also a strategy. These include restorative justice programs, such as Common Justice. Restorative justice for Oakland youth is another example, and then peacemaking programs, such as examples in New York City. And then finally, on the road to abolition, the principle of transformation applied to the courts looks like efforts to explore court injustices through data collection, as well as efforts to crash the system through the filing of motions against unfair police practices, encouraging everyday people to show up to and attend court, learn about the courts in their local communities, and organizing around not just prosecutorial elections, which has been a common sort of organizing effort, but also around judicial elections. So just want to invite you to take a look sort of on the right side of your screen at some further reading that I think really is aligned with the way that we're thinking about criminal court abolition and its possibilities. And then on the left is the contact information for myself and Amanda. I really want to highlight the @court listening on Twitter or X, whatever we're calling it these days, also on Instagram. But that's a project that we're doing in the Bay Area right now and really help to sort of motivate and guide. Really, that project itself is really motivated and guided in many ways by the work that Amanda and I have been doing and thinking in relation to criminal court abolition. So I invite you to take a look. All right, Amanda, your turn.
Okay, bear with me as I share my presentation. Can everyone see that okay? Okay, great, thank you. It's been a little while since I've been on Zoom and present, so thank you for bearing with me. Katie, Professor Smith, thank you so much for having Matt and me here today. I'm Amanda Woog. I currently live in the unceded Wabanaki territory that is also known as Blue Hill, Maine. I moved to this small hamlet from Texas about a year ago and have been taking a step back from a lot of this work. And so kind of being here, being in community with y'all is really a pleasure, and I really appreciate the invitation. I want to start with this quote from Mariam Kaba that I come to quite often, and especially in thinking back about the work that I did in Texas, the work that continues to happen in Texas, the work that I see organizers doing on the ground to dismantle oppressive systems. Everything worthwhile is done with other people. And so I'm going to talk today about really just some suggestions for where lawyers can support the movement towards the abolition of the criminal courts. And I want to start just by highlighting some observations that I've had over the years of seeing lawyers working and attempting to work in movement spaces. And I certainly think that there is a lot of room for us, but I also think that sometimes we tend to take up a lot of room. So this is like with a hashtag not all lawyers asterisk, but this is what I see as what lawyers tend to bring to movements and what lawyers tend not to bring to movements. And it's just a kind of, you know, a way to frame the positionality and the position that we occupy working on the ground. So we can bring access and positionality. What that means is it can be easier for an attorney to get a meeting with a judge to talk about the practices in their courtroom. It can be easier for us to reach out to a political actor to talk about the kinds of, you know, reforms or issues that we're seeing. And so that can be a way of opening doors and creating tables for others as well. We bring JD privilege, for better or for worse, deserved or undeserved. Sometimes having that JD after your name similarly gives you a certain amount of access, privilege, assumptions about the knowledge that you might have. Attorneys can also bring resources. Attorneys often are paid higher wages than organizers, unfortunately, or other, you know, legal professionals, paralegals, et cetera. And so I think lawyers are able to sort of harness more financial resources, and also, you know, printers, and, you know, just kind of thinking about the kind of things that we have access to in offices that other folks don't necessarily have access to. That's something that lawyers can also bring to the table. Legal and advocacy skills. I also see sometimes lawyers bring a focus on outcome and an ego and a drive to win as well, whereas organizing is more of a relational activity. Attorneys tend not to bring to movements. And again, this is tend because there are many exceptions to this, but direct experience in the injustices that we're seeking to dismantle, a personal stake even, intimate knowledge of the community and personal relationships within the community, and also a breadth of knowledge. Our knowledge can be very specialized. And so the next couple slides are going to be examples, suggestions that I have using examples in our paper for ways that attorneys can support work toward criminal court abolition. And these are offered in a spirit of exploration and learning, you know, mistakes that I've made. And it also is a way to point out and to bring to the fore that there's really a tension for abolitionist lawyers, and not just lawyers, but other people who are working within these systems. There's a real tension. How do you work within a system that at the same time you seek to abolish or dismantle? I think a lot of people probably go to work every day asking themselves that question. And I also want to shout out this resource that Katie already put in the chat, which is Beyond courts.org, which is like an incredible resource for real, practical framing ideas for working towards criminal court abolition. So Matt talked about power shifting. This is sort of one of the principles that we identified in abolitionist organizing happening on the ground, and that we then applied to the idea of criminal court abolition. And court watching in particular, I think there's a way for attorneys to be useful to community members who are looking to start up or continue court watching programs in their communities. So attorneys can do things like develop trainings and materials. I think, people who have not been in courtrooms very much, and I say this as someone who didn't grow up around attorneys at all, it can feel like a foreign language almost when you walk into a courtroom, and not even what's spoken. There's a lot of unspoken communication that happens that can be at the very least puzzling, but even more can appear is violent and unjust. And I think attorneys, as people who are around courtrooms more without necessarily normalizing what they're seeing and experiencing, can help people prepare and understand what they're seeing and experiencing. Attorneys can also help people get access to courts and court proceedings. Courtrooms are not always the most inviting places, and a lot of different court proceedings happen in ways that actually can be, almost secretive or opaque, including bail hearings that happen in the basements of jails that we've seen, or are only accessible via closed circuit TV. We've also seen that. So I think attorneys can really help people access and navigate courtrooms. With respect to community bail funds, this is an area where I think defense attorneys and public defenders in particular can support the bail funds by, again, helping get access to court documents, but also helping to identify people who are eligible for community bailouts. And then when people are bailed out and are on the outside, attorneys can continue to help support and to, obviously work on their cases and help make sure that they're successful on the outside. As far as defunding and reinvesting, this is the second principle that Matt and I identified around abolitionist organizing. I think that the courtroom and the courtroom players have really not been exposed to the kind of scrutiny that we've seen police budgets in particular being exposed to. But the budgets for courtroom and courtroom personnel are actually quite high. A lot of times when we talk about money that is going towards courts, people identify an issue with the parity between expenses towards defenders, public defenders, and appointed defense attorneys in contrast to prosecutors. So here are some suggestions for how lawyers can help shrink courtroom budgets while at the same time advocating for resources for the people who are being defended. And this is a picture on this slide of the day that the Travis County Commissioner's Court voted to start the first adult public defender office in Austin, which was like a huge community effort and really an important win for that community. But there is a tension and a question about how much time and resources should be spent towards advocating for more funding for defenders, given that it is part of the court system. So I also want to acknowledge that. I put a question next to be that judge or prosecutor because I'm not sure if this is the right way to dedicate resources. The progressive prosecutor movement, I think, in some ways has concentrated resources on prosecutors. And I think without a commitment to reducing the size and budget of that office, then there are real questions around, whether being a so-called progressive judge or prosecutor actually would help further abolitionist aims. And then the last point I had was support organizing campaigns to defund, reinvest by pushing back against system actors. And this really has to do a lot with what I've seen where a lot of people who work within courts who are attorneys will dismiss the demands of community members saying, they don't know how it works. I hear that a lot. They don't know how it works. They don't understand. And I think this is somewhere where attorneys can help push back on that kind of narrative because it's not true. But a lot of times, from my experiences, folks within the courtroom won't necessarily engage, with organizers. The next one that we highlighted was under defunding and reinvesting was ending user pay schemes. And I think a lot of folks probably already know what we mean by this, but this is basically structures where courts are supposed to pay for themselves or at least contribute to, and the way they do that is by extracting money from people who are charged with crimes. So that could look anything like people being charged for the cost of their probation, supervision, or drug testing, their monitoring devices. Sometimes people are even charged for the days that they spend in jail. Texas has a statute like that. And so I think one way where attorneys can be effective in ending these schemes are through individual representation and impact litigation, challenging them, and also joining advocacy campaigns to challenge the practices. One thing that I've seen that I think is important for people to hold on to and to pay attention to is that a lot of times when you're trying to end user pay schemes, the question is, well, where else does this money come from? And that wouldn't be a defunding and reinvestment strategy, because it would mean allocating more general budget funds to the court system. So that, again, this is not necessarily an abolitionist strategy if it's merely moving the way that the courts are paid for, probation departments are paid for. And the final principle that Matt and I talked about in our article was transformation. And I kind of posed the question of how to use the system against itself. And maybe this is helpful for those folks who go to work saying, how can I be a part of this system that I abhor? And what can I do to help dismantle it? And I think that this is one of the areas where lawyers really have the most intimate knowledge and capability to frustrate the operations. There are a ton of opportunities for creative lawyering that disrupt normal operations, such as mass motions or writs. I know in Texas, if you get a list of people who are in a local jail and their bail amounts, it's often the case that people are just unable to pay the bail that's been assigned. Even though there's kind of okay Fifth Circuit precedent right now on the kind of procedures that people have to be afforded in order to be held on bail that they're unable to pay. And so lawyers could get a jail list and start filing mass motions or writs challenging the amounts of bail that have been assigned because people are unable to afford them. Of course, we know about doctrinal development, judicial and prosecutorial accountability. I know that a lot of times we think about appeals as a way of fighting against orders that we think are unjust or wrong. But there are also other avenues, such as ethics complaints. For example, if you have a judge who's repeatedly refusing to give people bail hearings on bail that they're unable to afford, or collecting and publishing data and stories. This is where I think narrative can be really powerful. Again, I put progressive prosecutors and judges with a question mark here. And then finally, anti-criminalization or decriminalization campaigns, which could help just really narrow the imprint of the system by simply, not simply, but theoretically simply taking laws off the books that criminalize behavior that should not be punished. I wanted to kind of end on some questions, because I mentioned earlier that this article in some ways was an exercise in rage writing for me. And Matt and I started writing it the fall of 2020. And I think a lot of us can probably remember where we were in the fall of 2020 after the uprisings of that summer, still in quarantine a lot. And now that, we're about 3 years away, I find myself sort of trying to imagine what more presently can be done. Going from a deconstructing to really a constructive mindset. And I write today's futures as the theme for this slide, because I do think that we're not only imagining what this could look like years down the road, we need to be imagining and putting into practice what justice, accountability look like for ourselves and our families and our communities. And so these are just kind of prompts for people to be thinking about what could today's futures look like? How do I want to address harm with my loved ones in my community? And this is my contact information. I encourage folks to reach out for anything. And then this is a picture from the day, or I guess it was a week before, the Travis County Commissioners voted down a new women's jail in Travis County. And I was just emceeing, and I'm standing in front of a lot of people who themselves had been incarcerated in the Travis County jail. And they were really the leaders in that campaign. And it was really an honor to stand beside them in it. So thank you again, Katie. I'm looking forward to the conversation we have next.
Thank you both so much. I think that was a really helpful overview and useful to think about what are the kind of entry points for people who are currently working in the system to be able to start kind of making changes to the system as it exists now. And I think I would love to dive in a little bit more deeply into some of those aspects of things and kind of take things that I think can feel really abstract and try to make them more concrete. And that may be with real examples, as you've given so far, from communities that are already doing that, or just kind of drilling down a little bit more deeply. So one thing that we've talked about here, and I'm only going to ask a couple of questions because we're low on time, and then just open it up. But if people have questions brewing for yourselves, by all means, feel free to put them in the chat, and then we can kind of handle them in the queue in which they appear. So something like 80% of criminal caseloads in the US are misdemeanor cases, right? And many of those cases arise out of poverty and substance use and interpersonal conflict that might be mediated differently. And your piece, as you've mentioned, focuses on kind of power shifting, defunding and reinvesting, and transformation as these three pillars toward criminal court abolition. And I think you mentioned decriminalization very briefly at the end, but I would love to focus a little bit more on what that might look like, thinking about whether criminal law is the right tool to address those kinds of social problems, or what alternatives, even under the existing system, without a wholesale transformation, might exist. And in particular, what it would look like to decriminalize potentially large swaths of currently criminalized behavior, and then what are alternative ways kind of to deal with those social or regulatory issues that would not result in, let's say, like a civil but still punitive fee structure, as we might see in a system that shifts from criminal law to civil enforcement with a system of tickets in something that is formally decriminalized but still potentially going through a related court system, right? What would it look like? What's a different response to, for example, driving on a suspended license? I wonder if we could talk in that kind of concrete level. And that doesn't have to be the example you use, but just to get people churning on those kinds of questions.
Katie, I'm going to treat this like a brainstorm because it's a really great, important question. I just kind of want to riff a little bit on what you've said. I think we have to be wary of the civil legal system as well. I think there's a temptation, and Matt and I actually, a prior version of the article, we sort of said, like, maybe there's some potential in the civil legal system, and your students really pushed back on that. I really appreciated that, and that ended up having, we really rethought that. That system has its own ways of regulating Black families through the foster care system. And I think that systems tend to morph, depending on what's being asked of them and who is in front of judges. So I have a really big hesitation that I've learned over the last couple of years, I think, to moving into the civil system in that way. It also doesn't really address the like drivers of a lot of these so-called crimes, including poverty. Like if you just slap a fine on something that someone does out of poverty or dependence on substances, that's not really helping either. So I get why it would be tempting for people, and it would be, maybe a less harsh form of punishment. But I think it would just be a way of pushing people into another system that would have its own pitfalls. That being said, I support mass decriminalization of just about all. I say just about, like, I say that just because I'm a lawyer and I'd have to look at the code, but like I support mass decriminalization of all misdemeanors. Like it takes up an enormous amount of resources. And when you think about the resources that are being spent on like prosecuting and policing and imprisoning people, and how you could be using them to address more of the root causes, I mean, it would be absolutely transformational. So I would support decriminalization without kind of trying to come up with like another system that's really trying to punish things that I don't think should be punished at all.
Yeah, I would just add, I think, Brendan Roediger's piece is really good on this, around sort of abolishing the misdemeanor courts. In some ways, it's almost the easy, right thing. I think a lot of people through power shifting, right, through organizers on the ground talking about the ways that loitering laws, laws against people camping are absurd, and they're harming people more than anything else, and they're meant to just sweep poverty, right, under the rug through a punitive mechanism, rather than giving people housing and the like. And so, I think there's been really great work on sort of decriminalizing those sort of low-level offenses and the arguments around it. Now we need policy that backs that up, right? And so we need to advocate for making that exist, which I think many people in the United States sort of are already or are there intellectually, hopefully, to say, yeah, like someone shouldn't be arrested and pulled into the courts for loitering. Of course, there are many people who may think that still, and so I think that's where power shifting and decriminalization, in the way we think about it in the article, comes to the fore. I will also say the civil, I think in the piece, we sort of hesitate here still, even though I think my students definitely pushed us a lot with respect to civil. But I think over the past 3 years, both of us have developed more deeper critical thoughts around the problems of, adjudicating these kinds of quality of life offenses through the civil process. And I'll just say, I think it would be great to have more theorizing also about, and I think Dorothy Roberts has done a lot of work around this, so many people, but deeper engagement too about sort of the harms of the civil court system, which is often thought of as the place where people in power are going through the system when they face sort of criminal charges. And even though, right, people aren't necessarily pulled into prison directly through the criminal court system, we know that through fines and fees and the like, people can ultimately be determined that they're not willing to pay and then incarcerated.
Can I just add one small thing, which is I think we just need to be cautious in these discussions around decriminalization of misdemeanor offenses of who should be in a cage and who shouldn't be in a cage. And I think there's a little bit of danger in sectioning off people in that way when we all agree. Well, I can't speak for everyone in this Zoom room, but when we agree that it's unjust to cage a person, it's not whether certain people. So I think that's kind of my only narrative and real hesitation around that.
Totally. And that's almost why I sort of described it as I think almost the easier conversation. And I think a conversation that we try to have in the paper too is a harder conversation about crimes or things that have been criminalized that people sort of see as that's harm against another person, right? Assault, sexual violence, how do we deal with those in the absence of a criminal court system? And that's where I think a really hard conversation needs to be had about the possibilities for restorative justice. Danielle Surratt's kind of common justice, right, is a good example of this, but also ways that we can build up systems that prevent these harms from occurring in the first place.
I know we've got Sandra with a hand up and then a question from Patrick in the chat. So we're going to go in that order. Go ahead, Sandra.
Okay, thank you very much. Welcome to you both. It's good to have you here. I've had you on my mind since your paper came out, and so it's so exciting to finally have you as a part of this conversation. So I'm gonna ask a question and then play devil's advocate. You already know my politics, so I don't feel like I have to make any arguments about what I believe. So I'm just going to throw this out. There have been a number of court innovations, attempts to address the very issues that you all say that the courts have been ineffective truly in addressing, and that is just perpetuation of inequalities and degradations, et cetera, that continue, not enough. So drug courts and veteran courts and these kinds of things, implicit bias training. One question is, what then is the kind of manifest and latent functions of these kinds of reforms that are put forward, right? Because a lot of people will say, well, they're trying, and they're here's this fellow who benefited from that thing. Why should we not take that seriously? And I ask this because, if we're not just having an academic conversation, my assumption is that there are a lot of people out there who feel like, we need to try different things and eventually we'll get there. And I've had conversations with researchers who say, we can't solve poverty, but with these little kind of incremental changes, we can slowly get there. Look at the changes the trends over the last few years. We've made progress. We got to just keep doing these things. What is your argument for why we should, in a sense, kind of abandon it, just not working? Why should we go the route that you're suggesting instead of trying to figure out, as some argue, where the breakdowns are happening and plug those holes? What's wrong with that approach? And then I'll ask the second part of my question.
Yeah, it's good to see you, Sandra, and thanks for the question. I think for us, these are sort of within that world of sort of traditional reforms that ultimately often end up legitimating the broader system, sort of making it seem a little bit better and easier and not as problematic. But actually, ultimately, and specifically in the case of specialty courts, there's some good work and some that hasn't been published yet, but I can't wait for it to be published. Keep your eyes out for Mary Ellen Stitt's work, who is a professor at Albany. And other, Rebecca Tiger's work, I think, is really good at this, already published, long published work on sort of the problems of systems like drug courts or mental health courts that often first require a prosecutor's recommendation, right? So not everyone gets that, right? There's a determination already there that's often racially or class biased. But then often too, there's always some punitive system or lever that can be implemented at the end of the day if the person doesn't do what we say they need to do, right? And some people who use drugs, or some people who have mental illness, right, they can't control that, right? And so it's really hard to be a responsible citizen who's doing what the court says. And so oftentimes these programs set people up for failure, and then when they go back into the traditional court system, they're punished even harsher. And the failures, right, we know that the work on failure rates in these specialty courts show that typically it's, the same people. It's poor people, people who are really struggling with mental illness, and people of color, Black people and Latino people in particular, who end up going back into the system and then face even more punitive impacts from it. I don't know, Amanda, if you have other thoughts.
I would just add to Professor Smith, you mentioned like the people who say we can't solve poverty. I would say we can solve poverty. I think like that, when we start from that assumption, our like imaginations are so limited, and it's simply not true. We don't live in a nation of scarcity. Some people do, and that is eminently solvable. I think to add to what Matt said, just one more thing is that the entry point is the criminal system for these courts. The entry point is an encounter with the police and a funneling into that system. And that in itself is traumatic for people and for families. And if we truly want to help people where they are, I think we have to do it in a way that doesn't further induce harm and trauma.
I very much appreciate that. And I couldn't agree with you more. I just get so infuriated when people respond by saying, well, we can't solve racism and we can't solve poverty. And so let's go with these really small, pointless programs. But here's the other question. And this is a version of a question that Tommy Shelby asks in his latest book, which offers, I think, a really interesting critique on abolition of prisons. And that is, well, you know, the education system, for instance, is rife with all sorts of problems, but we don't talk about eliminating or abolishing the education system. We talk about constantly how we're going to fix it. And so his argument then is, the focus should then be, and if Tommy is still on, he can correct me if I have this wrong. The focus should then be on figuring out ways to address a system that we need because it has some benefits, and work to reduce the harms, but keep it. How would you respond to this argument? We have lots of systems, frankly, that have the exact same problems that you're talking about with regards to the courts, but we don't talk about abolishing those. We just keep churning along, trying to do whatever we can or not. So what's the argument for maintaining this argument with regards to the courts when we might not imagine the same argument with regards to other systems that are doing a lot of harm, maybe very similar harms or parallel harms in other institutions?
Yeah. So, one thing I'll say is, I think there are people who are talking about abolition of these other systems, and certainly the punitive logics that are infiltrating these other systems. So the education system, right? There's here too, kind of a two-tiered system. There's, those elite prep, wonderful, day and boarding schools. And then, but of course, they may even, and critical scholars have talked about how they even have forms of control, right? The education could be, right, preparing people for the labor market and controlling them in various ways and producing responsible citizens. But I think the ideal of education is an ideal of producing and making and helping people, right, learn and have knowledge and contribute to society in positive ways, in ways that they'd want to and hope to. But punitive logics have made it such that we have these Title I schools who are being reformed into charter schools, and there are no excuses charter schools, and punishing, right, mostly Black and brown kids more so than actually giving them, right, that wonderful educational support. And that's, I think, why reform tends to be more a conversation in the education space. Although I think there are people who talk about abolition in the education space. I don't know of a world where I can imagine that a prison system or a police system or a court system really has ever been imagined as, in the ideal, it's helping people to be better. Obviously there's a Foucauldian argument around prison was like initially this reform, right? But I mean, fundamentally, deeply, right? A prison, a police station, this is about control. It's about extraction. I think those are the fundamental logics that have always undergirded these systems. And I think we're arguing that there are better ways to prevent harm and also to hold people accountable.
Yeah, I would just add that, like, the system that we're talking about, the scale of it is unprecedented. The scale is also unparalleled in, what some would call like the free world and, different countries. So I think we're talking about a different animal. And for years, we've been throwing a ton of money at the system in the name of reform. And it's functioned to expand the system in different ways. So like when we see the reduction in the number of people who are in prison, we then see an increase in the number of people who are being surveilled, who are on probation or parole. So it's this monstrosity that continues to expand despite our efforts at reform. And it also, we don't talk about this much, but it's demoralizing, it's harmful, it's violent. It also separates family. Like it's intergenerational harm and trauma that's being perpetuated on the regular against families who are mostly poor and massively disproportionately Black and brown. And when you're starting from that point, I think we need to be talking about something completely different. I don't see it as a tweak. And, you know, in the wake of the way that we've expanded the system over the past couple decades, we've seen incredible defunding of education and social services, and we can't ignore that reality either. Like in a budget, it is a zero-sum game. And it's been at the cost of the kinds of resources and supports that could actually help people repair intergenerational trauma and harm, or repair after an assault or being the victim of some kind of violence. So it's doing harm in immeasurable ways that are not limited to the numbers that we're looking at of people in prison.
Thanks to you both.
All right, we've got time for probably just this one more question, which is, I think, a big question, and you each could speak at length about it. So Patrick, do you want to unmute and ask your question directly?
Yeah, sure. Thank you both for the presentation today, and I appreciate the comments. You know, I'm curious, actually. I think Katie, you led with this as well, but I do want to kind of push it to something concrete. What does accountability look like without the court system and without punishment when there's a retail theft from a merchant? Or what does accountability look like when there's, you know, relatively minor but important, perhaps dangerous behavior like speeding through an intersection or something along those lines? Could we just talk concretely about some of those issues, please? Thank you.
Can I take the speeding through an intersection example? Because I actually, in my small town in Maine, sort of had an encounter being on the budget committee about this when folks in the town wanted to increase the budget towards police because we have been having speeding issues at our main street. You know, at like the main intersection, we don't have a stoplight in our town. It's one stop sign. And there was a fatal accident a year ago, and it was, you know, traumatizing for the community and for the family. I voted against any increase in the budget. We don't have a police department, but sometimes we contract with the sheriff's department in our county. But you know, my suggestions for something like that was a speed bump or a, you know, one of those signs that says you are speeding, the speed limit is 25, you are going 40. And this is where like there's a lot of research that can really help us come up with alternatives, because I don't know if we need to be talking about accountability necessarily for dangerous behavior that doesn't harm. I think we have to talk more about prevention, and there's a ton of research that can help us sort of help, you know, guide people's behavior when it comes especially to traffic related issues.
I think prevention is an important thing, you know, but of course you're asking about accountability after the fact of harm. Just on the prevention point, I'll say sort of like example of retail theft, you know, there's really great social scientific research that talks about just place-based interventions, like putting out, you know, street lamps can just really help to prevent these kinds of criminalized forms of behavior. But on the accountability point, I think this is really sort of like kind of the reason we wrote the paper in many ways, was because we felt that the courts are the place where people think this is where accountability happens. And we really wanted to sort of first critique that notion, right? Many people are not actually held accountable in the way we would hope. A lot of people, when they go through the court system, because they're not allowed to speak, because they're worried and frustrated about the lack of accountability of policing in their communities, they leave the court process. You know, other than that sort of plea colloquy, many people often are not saying, yeah, I actually, you know, feel some sort of guilt for what I did and remorse, and I want to work toward, right, healing. It's when people are given the opportunity in restorative justice spaces, right, to be able to talk to the people that they've harmed and have the harmed people talk back to them and explain what's happened to them, right? Those are real spaces of accountability that our criminal court system, with its fast pace, with its focus on punitiveness, with its lack of ability to allow people the opportunity to actually share their thoughts, we really need a new system of accountability if we really care about that kind of accountability and restoration after the fact. And so I think the first step is mediation type programs, or sort of justice type programs. And they're really great concrete examples of that. And I think Danielle Surratt is going to come and talk about common justice. So I think that's sort of the example that I love to always talk about.
Thank you both so much. We are officially out of time. Our sessions end at 1:15. But I think the questions are generative, and I think, still may not be satisfying to everyone. And so I hope you'll keep coming back and keep engaging with us in the next, series of speakers as we figure out what does it look like and what is the process of accountability in the context of an abolitionist framework, right? I think in part that notion of accountability is separate from punishment for people who identify as abolitionists, right? That people think of accountability as being an internal process of acknowledging harm done and then responding to prevent that harm from happening again, right? And so what is that? Does punishment address that? Abolitionists would say no. And we're going to get into that more deeply, I think, in the next 2 weeks in particular. So I really appreciate the engagement, and I really appreciate you all being here. Thank you so much for presenting your scholarship and for continuing to engage. And I hope you'll all come back in the coming weeks.